Good morning, everyone. Welcome to the Thursday, July 10th, 2025 agenda meeting of the Minnesota Public Utilities Commission. My name is Katie Sieben. I chair the commission. The other commissioners that are present for today's hearing, I'll take the roll now. Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present, and we have just one agenda item on our docket on our list for today. Mr. Harvo, please introduce the Plum Creek item for us.
Good morning, Chair Sieben and Commissioners. Item number 1 is docket number IP 6997, CN 18699, WS 18700, TL 18701, involving Plum Creek Wind Farm LLC in the matter of the company's applications for a certificate of need, site permit, and route permit amendments for an up to 414 megawatt large wind energy conversion system and 345 kilovolt transmission line in Cottonwood, Murray, and Redwood counties. The questions before the Commission are, should the Commission approve Plum Creek's request to amend the certificate of need for the Plum Creek project? Should the Commission approve Plum Creek's request to amend the site permit for the Plum Creek project? Should the Commission approve the Plum Creek's request to amend the route permit for the Plum Creek wind project? If the amendments are authorized, what additional conditions, if any, should the Commission impose? Staff has the following opening remarks. Commissioner Tuma filed new decision options on July 8th. Copies are available in the back of the room. There is a technical error on page 9 of the briefing paper, being the first bullet on the company's requested amendment stating, requested to extend the date by which construction must commence until December 31st, 2028. This is incorrect. The correct information is the 5th bullet point, which states, extend the date by which construction of the wind project and the associated 345 kilovolt high voltage transmission line, herein collectively referred to as the Plum Creek project, to September 25th, 2027, or 2 years from the issuance of the site permit amendment, whichever is later, and extend the in-service date to December 31st, 2028, to allow adequate time for construction activities to be completed. Due to this, staff also notes that decision option 1 should also be revised to reflect the correct request. Staff has filed a revised decision option, and copies are available near the back of the room. Staff has no further remarks and is open for questions. Thank you.
Okay, thank you. If the parties could please come forward. I also see that Ms. Nakmus is online. And ma'am, I'm not sure I pronounced your name correctly. Could you please state your name for me?
It's Jean Nakmus.
Nakmus. Okay, welcome. Thank you. We may have questions for you. We'll begin on my far right with introductions and appearances, please.
Good morning, Commissioners. I'm Richard Gajewski. I'm the Government Affairs Director, and I represent the North Central States Regional Council of Carpenters, and I will also be representing the operators local 4 as well today.
Commissioners, I'm Randall Porter. I'm the transmission advisor for Geronimo Power, so all things interconnection fall to me, and I'm a professional registered engineer in the state of Minnesota.
Good morning, Commissioners. Jeremy Deere on behalf of Plum Creek Wind Farm, LLC.
Commissioners, Kevin Prentice on behalf of Leona, Minnesota, and North Dakota.
Good morning, Chair, Commissioners. Jamie McAllister with the Minnesota Department of Commerce.
Good morning, Chair, Commissioner. Suzanne Steinhauer with the Public Utilities Commission, formerly with Department of Commerce, EERA.
Excellent.
Great, thank you very much. This is a permit amendment, and we do have a little bit of a couple new decision options, or one staff revised one that as Mr. Harvo said, is not a big deal. And then Commissioner Tuma has one that he'll walk through. But before we get to that, did commissioners want to address any of the earlier filings that were in here? And Commissioner Hom, why don't you begin, please?
Thank you, Chair Sieben. So, welcome, Mr. Porter. So it's about the queue issue. So what is the current status of this project at the MISO queue? Which year, which phase is it in?
So currently the Plum Creek Q position that we're talking about is in DPP 2021 MISO study cycle, and it's currently just completed phase 2.
Okay. And are you aware that MISO filed expedited resource adequacy study special queue process?
ERAS, I'll refer to
Yeah.
that as. Yes, I am.
So why aren't you just stay on this Excel settlement and try to use that process to bypass this whole crazy MISO queue process? Not only you are going to bypass it, but potentially you are going to have a close to zero network upgrade out of it because they're going to update all those base case. I'm just very surprised that when I saw your letter and withdrawing from that settlement and bypassing that opportunity.
The ERAS is, we don't really qualify for that. You have to bring usually a large load with it, and it has to be at the institution of a load serving entity. So in general, ERAS was first proposed, we didn't qualify. It had to be an LSE.
No, I mean, if you, under that settlement, you have a PPA with Excel, yeah.
You did. They did.
If we could have completed it, yes. But
Yeah.
right at the time, we didn't have our transmission costs yet. Right at the time of the settlement, so we couldn't determine what our project actually cost. So we couldn't go forward with the Excel RFP.
I mean, under the ERAS, I think your expectation should be very low. I mean, I understand uncertainty, but basically ERAS is just giving out all those free interconnection to the certain fuel type. I think in Minnesota, you are the certain fuel type we prefer because particularly you are approved under the IRP, right? So that's why I'm very surprised with the letter that you are just withdrawing from that.
At that time, I mean, yes, I don't think ERAS was considered at that time, or if it was available.
No, I think it was heavily discussed. It was approved in other RTO. FERC was encouraging that MISO to refile it as soon as possible so they can do it quicker. So I understand it's your business decision, but I think, I don't know whether it's going to help you or not help you. It's your decision. You will bear the consequence, but I'm very disappointed that you guys are not taking that opportunity.
Understood.
Yeah.
Madam Chair and
Commissioner Tuma.
Commissioner Hom, in part, some of that's a question for Excel. I don't know, I can get SPP's process goofed up with MISO's process, but at least in SPP, it was the load serving entity that had to kind of bring the project to the process. I don't know if that's different in MISO or not, and whether XL should have brought this process. Maybe it's a question for them, but I don't know if that was ever brought to you by XL as a possibility.
No, it wasn't, not to my knowledge.
I mean, I think what would happen is that as a part of a negotiated settlement, XL would bring this as an ARIS project. That's how it would work.
But there, in my estimation, and Mr. Deere, this may be for you, not your July letter necessarily, but the earlier letter where the company was announcing it was withdrawing from the settlement, there seemed to be a lot of focus on the commission's IRP decision and blame placed on the commission for putting reasonable and normal ratepayer protections into the IRP settlement. That blame seemed to be not just casually, but kind of deliberately shifted onto the commission that in hindsight, it seems like now in your later letter, there's a bit of a other reasons why maybe the project was withdrawn from the settlement. But that earlier letter, at least the way I read it, was pretty critical of the commission. So where do you think things really are at now? What I mean, I understand we're here just for a permit amendment and I can get over that, but that wasn't the nicest letter that was filed without having it open in front of me again. But there were a lot of things focused at us which I think the commission made a very valid, reasonable decision and we haven't seen other projects or the IRP fall apart. So what do you think, in hindsight, is the real reason that you withdrew from the settlement? From the
Chair
order?
Sieben, Commissioners, our firm did not represent the project in the settlement. And so that was not a letter that I drafted or had any part in. The July letter that I can speak to is a letter that we worked to draft with Geronimo at the request of staff, just to clarify that the project is still active and some of the reasons for the delay and the cost uncertainty. I wish that I could address the withdrawal letter, but I'm afraid I can't because I didn't draft it and I wasn't involved in those decisions.
And there has been a change in ownership, is my understanding from the project overall. Then it was represented by, or it was owned by National Grid Renewables, and now it's Geronimo, correct?
Chair Sieben, correct. Although the change in ownership is really the owners of Geronimo Power, the owners of National Grid Renewables. The majority interest changed, and so the company name changed when the company got new ownership. Geronimo Power, formerly known as National Grid Renewables, still owns Plum Creek Wind Farm.
Okay.
The parent, so I understand, was the parent sell, now what we know as Geronimo, National Grid, to somebody else, or did somebody else just take it over as some sort of asset leveraging? I was a little confused at what exactly happened on the ownership structure.
Your question, Commissioner Tuma, is what was the change in ownership?
How did it happen? It was not the clearest thing to me.
National Grid Renewables was a part of National Grid writ large, right? The larger company. So we're part of actually an unregulated arm of National Grid called National Grid Ventures. So our business, National Grid Renewables, was sold to Brookfield.
So Brookfield, separate entity,
not unrelated, right? So we are now owned by Brookfield.
So you were a subdivision of that company. They were able to sell it off as a division.
That's right.
That Brookfield, in all essence, Geronimo owns this process.
Correct.
Okay. And I appreciate the later letter that helped us understand. We were aware of all these things. It's not one of the things I think some people think in this business, they can kind of blow smoke up our dress, for a lack of an appropriate term, when it comes to RTO issues, but not with these two guys sitting here. We kind of understand what's going on the RTO level for a purpose, because we see the importance of the RTO relationship and being able to accomplish our state mission to get some of these facilities built. And so we've been pushing to help people understand our RTO process is a critical one, and we want to see success. And so I don't think Commissioner Hom or us are saying, gee, bad on you for trying to work the process. We're trying to understand it, and we're trying to push it and make sure we're successful in that process. We're the most excited about errors, but it's there now. So let's take advantage of it if we can. And I'm hoping that maybe Excel is thinking about that. And with this project, I don't know what your negotiations are, but we as a commission want to see that RTO process work in our advantage. And that's why we've been actively engaged in it. So,
Commissioner Hom.
Thank you. This is a more general question I start to ask, so I'm going to ask you the same question. Since you have two circumstances, one is asking for extending the permit date in service date, and plus a change in ownership of the overall company. And I know your former holding company, they are very reputable and they are worldwide company, so I can understand their financial commitment. So I do not know much about your new holding company or the owners. What is their commitment to any financial commitment to the landowners and then the commissioning process? Because, sorry, I didn't do my own research on your holding company, but what is the level of their commitment and then credit worthy of that company who can enforce their commitment?
Commissioner Hom, that's a great question in that Brookfield is, the technical term I would use is ginormous, right? There's $1 billion hedge fund, right?
Okay.
So they're active in this area. So technically our company is now part of a renewable portfolio they're putting together, along with, they already own companies like Scout, you may have heard of, right? People who are rivals of ours or competitors. So think of it like Brookfield holds us in their new renewable portfolio that they sell to investors, right? Like a stock. That's my terms of it. So you can have both AT&T and Verizon in your portfolio, and they know they can still be competitors. So similarly with us, we're a holding within Brookfield's new renewable energy portfolio.
So their letter of credit can be considered as a top notch.
Oh, yes.
Okay,
Yep.
that's good. So being said, what is your current contract with the landowners? Because this project was proposed in 2019. Landowner who agree with you guys with the leasing their land made a deal around that time. I don't know when, because MISO was asking land control, right? So you had to do some negotiation. Are they being paid for their commitment? If they are not being paid, this additional delay, have you talked with those landowners?
So I think that's more of a question for Jeremy, but
Oh,
they are being paid. So the leases are being honored totally. So no question there.
Mr. Deere?
Chair Sieben, Commissioner Hom, I'm going to ask Jordan Burmeister to come forward to speak as to the leases with the landowners.
Welcome. Please state your name for the record.
Jordan Burmeister with Geronimo Power. Morning, Commissioners. Yeah, as far as the leases with the landowners, we've been very closely working with the landowners, for upwards of 6-7 years here now. And yeah, the leases are definitely being honored and continuing forward, with paying those landowners and honoring those leases so that we can continue to move forward towards, the anticipated start of construction and COD dates.
Okay, so my question is, are they being paid today?
Correct, yes.
Okay, so is there any difference between post and prior construction? Is there any difference in the price?
Yes, in the leases there is a development period, and then construction period, and then operations period. There's higher lease rates.
So before you file this one, have you communicated with those landowners, and have you heard any concern from those landowners because they are being paid less, and they can commit to another development, which may be developed faster because now MISO has a fast track under the certain circumstance. So they are losing that opportunity. That's why I'm just wondering whether you have talked with any of these landowners on potential.
Yes, and as far as more into that, our leases, we've actually started to pay higher rates given the long-term development of this project. And so those landowners are receiving a higher rate right now, and then once we go into operations, that would continue and then escalate up.
Okay, but I haven't heard anything yet whether you communicate with those people yet.
Yes, we've had landowner meetings. I think the last one we had was in 2023. We've had some other events we've held with landowners, communicating letters and updates, and we've done some. Last harvest we did a food drive where they come through and receive meals and stuff. So we're continuing to be involved with the landowners in the community to make sure that they're aware of the status of the project.
So when are you filing this? Have you talked with those landowners about this term?
The extension here?
Yes.
We've communicated to landowners our timelines, for the project.
Okay. Thank you. And then I have a question on this reconfiguration, but if you have a question, go ahead.
What?
Okay.
Before we get to that, I just wanted to hear Mr. Pranis and Mr. Kajewski, thanks for being here. Did you want to provide any overall comments on the project or the permit amendments that are proposed here?
Thank you, Chair Sieben, Commissioners. Again, Kevin Pranis on behalf of Lyuna, Minnesota, and North Dakota. This is a project that we've been involved in for a very long time in the permitting process and hoping to see built. One of the early projects that sort of got tabled as a result of transmission congestion, still tabled for transmission congestion, but we really like to see it built, hope to have it in the Excel portfolio, but regardless, there will be a demand for buildable projects, especially with the changes at the federal level. If it can get done in a timely manner, obviously there will be a huge amount of demand until there's, until those prices go up. And so I think it's important that we do whatever we can to make that feasible. I'll also just say in terms of the new ownership, we certainly have familiarity with Brookfield. I would say that this is a very common structure among renewable developers. So for example, Apex, which folks are familiar with, is owned by a similar large infrastructure fund. So, the two kinds of national developers we see are either owned by large utilities, often European-based utilities, or they are owned by large infrastructure funds. And so it's pretty common. It's common for many of the developers that come before you, and I think a reasonably reliable source of guarantor. So look forward to hope this gets approved, support the staff's decision options, but mostly we just want to see it move forward. Thank you.
Thank you. And Mr. Kajewski?
Thank you, Chair Sieben. Again, I'll be real brief as well. Both the Carpenters and Local 49 support the project. It's a large project, and we have been in conversation with Geronimo and with potential contractors for this project. We believe that this will be a good family-paying union project as it moves forward. We think there's a great opportunity to extend Minnesota's renewable energy goals through this wind project, and we would encourage support from the Commission. Thank you.
Thank you. Before we turn to specifics of the, or to Commissioner Tuma, one other question I had from the record, Mr. Deere or Mr. Porter, is the turbine height or the turbine size is changing now. And I think that the overall number of turbines would change too. I saw in the briefing papers that it was still kind of like up in the air what it would be. Is there any, you don't have to give specifics, but I'm just curious if anything either resulting from changes at the federal level or other construction updates you have about the types of turbines you have that, not that I'm really going to know the difference, I just was curious.
Want to kick the models?
Well, no, I know it was going to be like the really, really tall turbines, and now it's more like the size turbines we see in Minnesota. So any updates on, you still haven't purchased equipment or the turbines itself, I assume, and anything else to update us on there?
Chair Sieben, Commissioners, correct. The turbines have not been purchased, and that's why there are still 4 options, right, or those options that are presented in this amendment. The larger turbine options that were in the original permit, we thought that they were going to be to market by now. They are still not. And so these turbines are those that are available in the market that could fit within the parameters and constraints for this project.
And are all the turbine manufacturers that you're considering the same company? Are they Danish? Or you don't know? I'm just curious if you are working with a particular contract or type of turbine. Are they Vestas or you don't know?
Chair Sieben and Commissioners, they are Vestas and GE. So Vestas is the Danish company.
Mm-hmm. Okay, just curious about that. Commissioner Sullivan.
Thank you, Chair Sieben. I was curious, what is the likelihood, and I think this might be for you, Mr. Deere, but maybe for you, Mr. Porter. Is it going to be possible to begin construction for this before the end of 2027 so that you're eligible for the new PTC? Under the definition, the IRS definition of begin construction.
Commissioner Sullivan, yes, I believe so, for certain before 2027. I mean, we're timing now. A lot of our delays are, again, due to the MISO study process, We now have DPP2 study results, right? So we're moving forward on the transmission fund, let us be able to price our project. Looking forward to a GIA in Q1 of 26. So then we start
Q1 of 26.
26. That's the current MISO schedule, and then we'd be starting construction certainly before 27.
And then, let's say you get your GIA 26, and then you're in talks to find a buyer for the power after you get the GIA. I'm assuming you're in talks now, but
Right,
you'll
but-
have that lined up.
Commissioner, yes, back to the previous discussions, that it's impossible to price these projects until you basically have a GIA, right? We can't tell a potential off-taker what the power is going to cost until our transmission costs are nailed down, and now that isn't until you get a GIA, basically.
Right.
So we can't finalize any power negotiations until that time.
Okay.
Well, they could, but their financiers wouldn't want to take the risk, so.
Well, yeah.
Exactly.
Yeah.
Ready to get down in the weeds, or, oh, no, week one. Mr. Hama?
Yeah, thank you. I mean, it's close to that, but I think a more high-level question. I think this new reconfiguration discussion, company is saying that it's better and good. Why didn't you propose that initially in that case? Do we have any hole in our process that we approve something is not better and efficient, even though there is a better and efficient alternative?
Do you mean the shorter transmission line,
Yes.
Commissioner Hum?
Chair Sieben, Commissioner Hom, the transmission line was shortened to really satisfy some of the efficiencies the project was trying to seek as far as cost and pricing. In the original design, it was understood, it was constrained by the locations where the collector substations had to be. With some additional negotiations with landowners, we were able to reconfigure those substation locations. And that allowed, and talk to additional landowners to get a more efficient route. And so a lot of this was done over time, realizing that there needed to be some cost savings to make the project, continue to make the project more competitive.
I mean, that's why the high-level economist concern is, yeah, you could have done better, and you didn't do your job in the beginning of your initial filing. Now you are claiming that this is better than before. Yeah, it doesn't make any sense to me, because you should have done better job in the beginning. You should have find this better alternative by negotiating with the landowner at that time, not later to find better alternative. So that's why I was wondering what's going on. What is the true nature of reasoning you are changing it? And whether there is any sacrifice we have to make to change this configuration.
Mr. Deere, you weren't the attorney before?
That is correct, Chair Sieben, Commissioner Hom. Oftentimes landowner negotiations take time, right? And not every landowner is willing to enter into an agreement, and sometimes they decide to enter into agreements later. In this case, believe that was part of the reasons why we couldn't put the route in this location, and why we can now. In reality, it is a better route. It is a shorter route. And I think getting to a better solution, although it may be messy and it may take time and it may be frustrating, having a better project to be constructed is a good result.
Okay. Under that circumstance, have you talked with all the landowner potentially need to sign lease with you, and did you get all those agreements for this new configuration?
Chair Sieben, Commissioner Hom, all of the land that's needed for the project in this configuration has been secured.
Okay, including right-of-way?
I'm sorry?
Including right-of-way for this new transmission line, the collector station.
Commissioner Hom, that's correct, including the right-of-way.
Thank you.
We'll drill down that in a little bit more when we get to that. There's still some questions there, but that's okay.
Guys, one more.
Yeah, go ahead. Go ahead.
I know we're ping-ponging back and forth now, but I want to go back to if you do not get a GIA by Q1 2026, does the company have any plans to work with the utility that you would be getting the PPA with on an ERAS determination? My concern is that we have a pretty tight window here now to maximize what remains of the IRA tax credits. And I think that the utilities should be thinking about using ERAS to maximize the generation that comes online in the next 2 years, so that we can maximize the use of those credits. I think that's consistent with how ERAS works. And even if it's in the gray area, I would encourage the utilities to push. We have 5-year plans and resource plans that these projects fit into them. And in my mind, that's an ERAS project. So I'm curious I would expect that you are game planning out multiple scenarios if you don't get that GIA in Q1. But I hope you're talking to the utility about an ERAS determination, but feel free to opine.
Sure, Commissioner Sullivan, thanks for that. We are safe harbored on this project, right? So we have safe harbor equipment, and that's in law. The executive order issued on the 7th, I think it was, won't change that. An executive order can't change codified law, right? So we have safe harbor equipment that we believe, enables us to qualify under the old rules, basically, before these changes in, I'll call it BBB, right? Depending on how the IRS still has to weigh in on that under the executive order, and they may change some timelines and stuff, and we'll see what happens with that. And then maybe ERAS will consider that as an option. Back, I think to your first question, I'm pretty confident now that we've got DPP2 results. Things are going to move faster in MISO and move toward a GIA. But you're right. I mean, the MISO process, there's typically delays, as you can see by our last letter, right? So are they going to maybe be Q2, Q1, Q2? I don't think that would appreciably impact our ability to construct the project by the end of 27, start in 27 and be done by 28.
Thanks.
Commissioner Hunt.
Thank you. Chair Stephen, it's one follow-up to it. Okay, a lot of wind project dropped us because unfavorable outcome. Because you have a DPP study done doesn't mean that it will happen, right?
Our latest results are very favorable, Commissioner Hum. So we have every anticipation of moving forward on the transmission front with our current queue position.
So based on what you are expecting from the prior study or DPP study, so you are not expecting uncertainty or network upgrade cost, which can be reasonable. I meant favorable. So if your interconnection cost is unfavorable, can you find off-taker?
Again, I don't anticipate, Commissioner Hom, that our interconnection costs at this point are going to become unfavorable.
And I'm hearing two different stories. You guys drop out from the settlement because uncertainty in the interconnection cost. Now you are telling me that you can predict is favorable. So I'm hearing very different story.
I'll try to clarify that, Commissioner. We cannot price the project precisely to meet the needs of the Excel RFP at that time, right? So we couldn't meet the cost cap, right? We don't know what our interconnection costs are at the time.
There wasn't a cost cap in the IRP. It's just not accurate. There was not a hard cap in the IRP.
Yeah, I lost it.
That was part of my frustration with the
but
earlier letter, is it wasn't also accurate that the commission was willing, like in past IRPs, to look at costs if they went up for different reasons and to be reasonable. And the previous company or lawyer sort of made it sound like that we had done something unreasonable. And when you say cost cap, that sort of triggers me and me feeling like we were unreasonable in our IRP order. And I just want to defend the honor of my fellow commissioners here that we deliberated about this extensively and I think arrived at a very reasonable place. So sorry to interrupt Commissioner Hom and
No, no,
to
no, I mean-
interrupt you, sir, but it is like it's a point of contention a little bit, because we as a commission have to balance when you have a suite of projects come in under a negotiated settlement between various parties, including Excel, obviously at that point, we either take it or we don't, right? More or less, but that's, I think, why it was so difficult, the discussions around the cost cap. So, I don't know if I'm being clear, but I just want to say that, like, our IRP decision, it's never easy, and it's certainly not easy given the rapidly changing landscape of the, of the federal government and other things that were happening with tariffs and other things. So I understand that, but I just want to try to convey to you that I think we were reasonable in saying when we approved the settlement, projects could bring back decision or petitions where the cost changes, and we would have been reasonable in looking at those. But by having the company pull out completely of the IRP, now you're just sort of adrift. And like, we want the project to move forward, but that was a decision that was made, and now, we're struggling with how do we still see the project move forward at a price that's reasonable and balances the different changing landscape that we're seeing. So, sorry, Commissioner Hom, I took over your question.
No, I'm also very frustrated. At that time, I pushed for the harsher condition and I lost. And then I clearly remember that discussion, because exactly this reason, other commissioners was pushing me back, not putting on the very harsh condition. So I took it very hard, but I took it because now I see the wisdom of other commissioners pushing me back on that issue. But now you say your interconnection cost is favorable, that means relatively predictable. So I don't see any good reasoning why you drop out of settlement with uncertainty, because we do not have a hard cap. And interconnection cost was predictable in reasonable range. Otherwise, you don't call it favorable. I don't see any reasoning that you can support that your news release blaming commission that, oh yeah, because commission decision, we cannot do it with MISO's cost uncertainty.
Let me, if I can, Chair Sieben and Commissioner Hom, address a couple points there. Yes, I agree that I understand your reasoning in the past in the decision to your duty to protect the ratepayers, right, on what you were trying to do. So I certainly lay no blame on the commission for our decision to withdraw. I certainly don't. That's totally a company decision. I don't think it's any fault of the commission's, right, that predicated that. But to Commissioner Hom's point about transmission costs in February or in April, when we did not have that surety on costs. We just received the DPP study results, which show things to be favorable June 24th, the draft, and the decision point just started here it will terminate, the decision point will end next week on the 16th. Right, so we did not know.
What will end next week?
The decision point, so during the MISO process, there's decision points when you move forward. You get study results and the commensurate costs, right? At the time when we withdrew, those costs were hundreds of millions of dollars, right? And unknown what's going to happen. Now, with our new study results that arrived in late June, they're much more reasonable. And so we have a better clue on how we can move forward.
Okay, just one follow-up. So is a Plum Creek ERIS or NRIS?
It's NRIS.
So NRIS, you don't need the off-taker to get the final accreditation then?
Correct.
And then still you are expecting favorable interconnection cost?
Yep, our costs include both the ERIS and NRIS costs.
Okay, so under even NRIS, you think it's a reasonable cost?
Yes, I do, Commissioner.
Okay, thank you.
In the resource plan, wouldn't you have been connecting through the Minnesota Energy Connection, though? You wouldn't have to go through the MISO process, right?
Connecting to Hampton, Brookfield Hampton.
If that was, there would an option be there, yes, you would use Minnesota Connect, I believe. That was a different version of the project.
So if that were, that would be very knowable what those interconnection costs are, right?
This is, again, referred to our queue position, right? I mean, I think we were envisioning using our queue position at that time.
Okay.
And would you would have to have a whole new route then? I mean,
That's right.
So, okay, can I follow up? So, what if you decide to drop out from the 2021 queue and trying to interconnect with the Excel Minnesota Energy Connection? What could have been your additional length of interconnection transmission line?
I don't have that right at my fingertips, Commissioner. Sorry, Commissioner Hom.
Okay,
we
but
could get that for you.
how far is it? Is it reasonably far enough for?
how far is Gavin from?
Yeah, how many miles, Jordan? Yeah, it's a ways, 20, 25 miles. So that, additional $50 million, let's say.
No, but at least you can predict it, right? Because interconnection, you say unpredictable, that could be part of the negotiation.
I'm ready to go.
You're ready on your,
Let's get into the weeds.
I got no.
Let's get a permit done here. Maybe. We'll find out. Let's just start working through the decision options. I think that'll be the easiest, Mr. Deere. Our staff has a revised decision option 1, which I'm assuming is fine because I think he was responding to language in your filing. So tell me, is revised decision option 1 okay?
Chair Sieben, Commissioner Tuma, a revised decision option 1 is okay.
And then as far as the site and route permits, let's start with the site permit first. I'm inclined to believe that all of the decision options under number 2, A, B, C, and all the subparts look good to me. Any concerns that you have?
Chair Sieben, Commissioner Tuma, no concerns.
3 will be a little bit more work. I don't know if the individual on the line, you can turn your camera on now because now we're talking about route amendments. And please state your name again so that I can have it and not mispronounce it.
My name is Jean Nakmus.
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 I think I can handle it. Nakmus. What is that? Is it German or I can't quite make it out.
You're right. It's German.
Okay. It's a new one to me. It's a good one though. So, Ms. Nakmus, we're going to kind of get into the details. I don't want you to be surprised. We'll talk about your specific area at some point. There's just a couple other things that I want to deal with on the permit language, and I got a little nervous when they heard that all the landowners are lined up. Okay, and it really goes to the language in the permit, and you can see the evolution, Mr. Deere. I'm sure you're not unaware of some discussions with Excel prior, and so we've been talking about what is the authority of the permittee in the 1,000 feet. And as I hear that, I'm looking at the designated route language we have, and I'm inclined at this stage to make it very clear that the alignment means something. It will relate to Ms. Nakmus's situation and also to the DNR situation. I think the language we intend to have, we view is, and I viewed permits all along, the alignment is the alignment. It's a line on the map. It means something. We've decided on that line to fit within the statutory criteria, and that it's the best one to meet the statutory criteria that we have on the record at that time, and it can be modified for 2 reasons and 2 reasons only. Landowners coming to you and asking you to move it, and then we ask you to stay generally close to that alignment because we selected it for a reason, or there was an unknown circumstances. There was a burial ground there or a cemetery we didn't know about, whatever. There's something that's on that side, or it's quicksand, and we can't put a pole there, and we need to move in. So
how many times has that happened?
I don't know how many times we find quicksand out there.
I'm surprised you don't know.
Yeah, I would probably say 0, Madam Chair, but I'm being a little facetious. And so when I look at this one, I would like to, and JD, I'm going to put you on the spot. I might dictate something, so get something up. On something along this, that section 3 is amended to clarify that the alignment on the map is the route selected with flexibility to make changes within the 1,000 feet. I think that conforms to the way we do permits now, and I think it helps this situation out with the existing landowners in the DNR. We'll get into that specifics in a second, but I would like to make sure that our section 3 is amended to make it clear the alignment on the map is the route, and that you have flexibility within the 1,000 feet to move the alignment. Thoughts? Mr. Deere.
Chair Sieben, Commissioner Tuma, I think that's our understanding with the permit language as it was. So that further clarification is fine.
And then we'll start first with the DNR. I'm going to start from the route from the south heading north, okay? And there's a DNR section. There's a turn there, and our staff has put in language here, which is B Romanet 4, and it says require Plum Creek to work with DNR to mitigate the effects on, there's a DNR wetland or something there. There's, looks like a creek there, and there's some prairie land or something that's a DNR land. Don't know all the details yet, but that's something we expect you to go work out with them. I'd like to add in there to develop a mitigation plan in cooperation with the DNR and impacted landowners so that the neighboring landowners are involved in the discussion. Any concern with adding that language to Romanet 3B?
Chair Sieben and Commissioner Tuma, no objection. In order for this to work and truly minimize those impacts, it will have to go onto a construction traffic will have to go onto a neighboring landowner's land to make sure that that area is avoided.
And one of the things that, talking about the line that you're talking about that ends at Hampton, I drive under it every day, so I see it bouncing, doing 45-degree angles. I assume you're going to possibly have a situation where you have the line extend out into the neighboring landowner's property, maybe do a 45 angle there. I think that's a fair mitigation, okay, that if you can work it out with the landowner, instead of doing a corner post where the DNR property is, do a 45. And is that something that the developer is open to in situations like that? Again, if the landowner is consenting to a line going across their field.
Chair Sieben, Commissioner Tuma, I'll ask Mr. Burmeister to correct me if my recollection's off. But my understanding is this landowner wants the 90-degree turn because of aerial crop spraying in the area, just to try to minimize the impacts across their field. Is that correct, Jordan? Yeah, thank you.
And different landowner to the north is my understanding on that particular alignment. Now, as you go from the DNR spot over towards Miss Crank Moss. Nackmoose. I'm dyslexic, Miss Nackmoose, so forgive me. He knew I was going to pull out the dyslexic thing at some point. Miss Nackmoose. I'm also getting old and fading in my days, too. So I just pronounced names wrong, too, yeah. So I apologize, Miss Nackmoose, but on the route from the DNR spot over to the Nackmoose property corner, I'll call it for now, the new landowner in the north, I don't know if he has the same concerns where we could possibly do a 45 at that corner across County Road 7.
Chair Sieben, Commissioner Tuma, we believe that landowner to the north has generally been very cooperative, and definitely something that can be brought to that landowner about doing a kind of a cutting the corner and moving it farther away from the Nackmoose property. And so that is something the company they're comfortable with the revised decision option that you provided, and it's definitely something to pursue.
I think to be accurate, Ms. Nackmoose, the alignment actually touches your property. They would have to get a 75-foot easement from the Nackmoose property in order to put a corner where the alignment is now, and I'm assuming because she is here, she hasn't agreed, or that as a landowner, they haven't agreed. Is that my understanding, Ms. Nackmoose? You haven't agreed to any poles on your property at this stage, have you?
No, we have not. No one's approached us about anything to do with this part of the project.
So my guess, by you saying that you have all the landowners under control, is that more than likely you would have moved the corner post up north of Ms. Nackmoose along County Road 7 was the plan. Is that my understanding, how you can say that we have the landowners locked up? You're already planning on moving it and not being a direct, absolutely 90-degree angle. Is that correct?
Chair Sieben, Commissioner Tuma, it's my understanding in the detailed design that it does avoid the Nackmoose property. So the pole is not sited on her property, and we will make sure that is the case.
Ms. Nackmoose, I don't know if you saw my decision option at all. It probably doesn't make you completely happy. I can understand. I'm looking for the developer to talk to your neighbor to your northwest and to see if he's willing to put the line. They're usually poles are about 1,000 foot apart, is my understanding. I don't know if that's generally in that framework. It would put it further away from your property, but it would still be, as you drove out the driveway, you would see it off to your northwest. So that's what my decision option says. It basically says they need to work with that landowner. If that landowner's okay with it, they can do a 45 across his field. And you can comment on it. I would expect that you just don't want it in your neighborhood, and that's perfectly fine, and you can tell us why now.
Well, thank you. First of all, thank you for allowing me to attend and speak at this meeting, all of you commissioners. I have supported alternative energy projects in the past, and all I'm doing is trying to keep my family safe because of the placement of that transmission line so close. It was right on my property line where they did the borings. And that alarmed us because my son, his wife, and their two small children, ages 3 and 5, live there. They have livestock. And even though there have been studies done, I'm not so convinced that those studies would clear them to live there. With that said, my neighbor to the north, I'm sure, is in favor of this project. We've discussed it. I'm just trying to stick to my late husband's decision about not placing any of these things on our property.
And it sounds like that is going to be their intent, and it sounds like they're willing to see if they can even move it further away from your property. And that's what my decision option is tending to do, is to try to encourage that movement. I appreciate your being here and your thoughts about that. I did see it. I drove by your property, but it was a long time ago because this project is old, and I remember driving up 7. So I wasn't looking at it for this reason, so I had to use Google Maps to kind of see what was going on there. And I appreciate your input and your thought on this. Overall, though, because it's a shorter route, I'm inclined to think that that's, first of all, better for ratepayers. And second of all, it does impact less landowners. One landowner that would have been severely impacted is someone that would have had the power line on their east and their south side of their property, their farm property. And as you know, when you build windrows in Minnesota, they always go on the north and west side of people's property. So your windrows do block a little bit of that view, not the electrical concerns that you have. But I look at the impact of the one landowner that would have had it on their south and east side, and their view would have been even worsely impacted. And so when you look at the resident impacts, I know for you it's not any better, but overall what we have to look at the commission is to say, is this better or not better? And it seems to be, from what we see on the land and from the environmental studies that have been done on the land by the applicant and our staff, that this shorter route is better. I know it's not better for you, so I apologize. So we're trying to find to mitigate that damage, and so I hope you understand that.
Yes, if they can move that further north of the building site, we would be very happy and appreciate your attention to this. Thank you.
Excellent. The next one I have, Madam Chair and Mr. Deere, is 3C. You weren't the attorneys on this before, but some of your friends were, and there was a reason we put this in there, but I'm hoping that reason has gone away. Do you have control of all of County Road 10 properties, including this particular one that we're trying to extricate from the permit language.
Chair Sieben, Commissioner Tuma, this was something we probably should have captured in our amendment request because that land has been secured, that the bump out, as it were, that where the language was inserted in there to accommodate a deviation from 10 is no longer necessary.
So 3C is okay with you?
Correct.
And excellent, by the way, thank you. Even though you weren't the attorney that did it, you can thank the attorney that did, because I don't think that was an easy negotiations, would be my guess. And so to your staff, excellent work. I appreciate you taking the extra effort to do that. So, Madam Chair, I think that is all I have for questions. I can make a motion, and Madam Chair, I would move staff revised decision option 1. I would move staff, or the decision option 2, A, B, and C in all Romanettes. I would move decision option 3, A through Roman numeral 5, and then I would add the new section. JD, do you have some language that you could throw up for the section 3 alignment? And then I would move Tuma's new 3D, I guess it is, clarify that the alignment on the map is the route, and Plum Creek has flexibility within the 1,000 feet to move the alignment. And later in the permit, it says that you can move it for 2 reasons: unexpected circumstances and landowner, working with landowners. And then I would move decision option 3B, all Romanettes, along with Tuma new 3BV to address the concerns of the landowners on County Road 7, and then also Tuma new 3C, and then finally decision option 5.
And Mr. Deere, did you have a chance to follow that whole motion, and did you have any, I'm not sure we ever asked you, like, if you were okay with all of those, staff revised decision option 1, for example, and what Commissioner Tuma just said. So any comments on the overall motion?
Chair Sieben, Commissioner Tuma did ask me right at the beginning of his remarks on the staff revised
Okay.
decision option, so we are good.
On the whole motion?
Correct.
Okay. Anybody else have any concerns on the motion they wanted to share? Any comments from commissioners?
I guess the only one that I would ask, maybe just the department, because we didn't talk about certificate of need, and I thought you were okay with the extension, and only 2 years, not 4 years like some we've done before. So.
Ms. McAllister?
Thank you, Commissioner Tuma. The department has no objections.
Okay. Any further discussion on Commissioner Tuma's motion? All in favor, please say aye. Aye. Opposed? The motion prevails 4-0. Thank you very much, everyone, for your work, and we look forward to seeing the project move forward. There's no other business. There's no other business before the commission, so we're adjourned for the day. Thank you, everyone.